Almighty God, we give thanks to you, the creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this house here assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established among us for all generations. Amen, amen, namaste. Oath or affirmation, announcements by the Speaker, petitions, papers. The Minister of Finance.
Madam Speaker, on behalf of the Minister of Finance, I have the honor to lay the following papers. Paper number 1, the report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Police Complaints Authority for the year ended September 30th, 2019. Paper number 2, the audited financial statements of the Deposit Insurance Corporation for the year ended September 30th, 2019. Paper number 3, the consolidated audited financial statements of Evolving Technologies and Enterprise Development Company Limited for the financial year ended September 30th, 2018. Papers numbers 4 and 5, the audited financial statements of the Youth Training and Employment Partnership Limited for the financial years ended September 30th, 2018 and 2019. Madam Speaker, I beg to move that papers 1 and 2 be referred to the Public Accounts Committee and papers 3 to 5 be referred to the Public Accounts Enterprises Committee. Thank you, Madam Speaker.
Honorable members, the question is that papers 1 and 2 be referred to the Public Accounts Committee and papers 3 to 5 be referred to the Public Accounts Enterprises Committee. All in favor say aye. Aye. Any against? The ayes have it. Leader of the House.
Madam Speaker. Madam Speaker, I have the honor to lay the following papers. Paper number 6, the response of the Auditor General to the 24th report of the Public Administration and Appropriations Committee on an examination into the processing of payment of pension and gratuity to retired public officers and contracted employees. Paper number 7, the ministerial response of the Ministry of National Security to the 8th report of the Joint Select Committee on Finance and Legal Affairs on an inquiry into the adequacy of magistrates' court facilities. Thank you, Madam Speaker.
Reports from committees. Member for Chaguanas East.
Thank you, Madam Speaker. I have the honor to present the following reports. Number 1, the 14th report of the Joint Select Committee on State Enterprises on a single evidence session with Telecommunications Services of Trinidad and Tobago. Number 6, the 15th report of the Joint Select Committee on State Enterprises on an inquiry into the operations of tourism agencies in Trinidad and Tobago and to determine their effectiveness at fulfilling their mandate. Number 7, the 16th report of the Joint Select Committee on State Enterprises on an inquiry to assess whether the National Information and Communication Technology Company Limited, IGovTT, has been fulfilling its mandate, and if so, to what extent? Thank you, Madam Speaker.
Member for Faisabad.
Speaker, I have the honor to present the following reports. Number 2, the 28th report of the Public Administration and Appropriations Committee on an examination into the maintenance of community pools by the Ministry of Sport and Youth Affairs. Number 3, the 29th report of the Public Administration and Appropriations Committee on an examination into the delivery of projects and programs by the Ministry of Social Development and Family Services. Number 4, the 30th report of the Public Administration and Appropriations Committee on an examination into the preparedness and response of public authorities to the COVID-19 pandemic in Trinidad and Tobago. And number 5, the 31st report of the Public Administration and Appropriations Committee on an examination into the internal controls and expenditure of the Elections and Boundaries Commission. Thank you.
Member for Miaro.
Thank you, Madam Speaker. I have the honor to present the 11th report interim of the Joint Select Committee on Land and Physical Infrastructure on an inquiry into measures for ensuring water security in Trinidad and Tobago.
Member for Aruka Maloney.
I have the honor to present the report of the Joint Select Committee on the Constitution Amendment Tobago Self-Government Bill 2018 in the 5th session 2019-2020 11th Parliament. Madam Speaker, there are some very noticeable recommendations in this report, and we'd like the Parliament to take note of the recommendations. Thank you very kindly.
Prime Minister's questions. Member for Couva South.
Thank you very much, Madam Speaker. Madam Speaker, question number 1 to the Prime Minister. Given that the Prime Minister of Antigua and Barbuda recent announcement of plans to liquidate the regional airline Liat, and given the fact that Caribbean Airlines suffered an estimated operating loss of TT $96.1 million between the period March to April 2020, could the Prime Minister inform this House whether CAL will commence a restructuring exercise before the resumption of full operation?
Prime Minister.
Madam Speaker, CAL continues to review its operations on a continuous basis in line with industry best practices to ensure the company's survival, including prior to its resumption of its full operations.
Supplemental, member for Couva South.
Minister, given that the operating loss was up to 2020, are you in a position to, for example, provide us with an update on the operating loss, as, let us say, up to June of 2020?
I know that you know that I can't tell you that just like that. So I will advise, Madam Speaker, that this be filed on notice.
Supplemental, member for Couva South.
Prime Minister, given what has been happening in the airline industry worldwide, major airlines have embarked on restructuring exercises and job losses into the thousands and so on, regionally and internationally. Are you in a position to guarantee that when CAL resumes its full operations, there will be no job losses?
I will not allow that as a supplemental question based on the question asked and answered. Member for Oropuch, member for Pointe-a-Pierre.
Thank you, Madam Speaker. Question number 2, could the Honourable Prime Minister outline the timetable proposed for the work and report of the Cabinet-appointed Community Recovery Programme team?
Prime Minister.
Madam Speaker, the committee has just been mentioned a few hours ago. The committee has not met, and this question is premature.
Supplemental, member for Oropuch East.
In light of the establishment of this committee and the announcement, is the Prime Minister aware of a 2013 extensive 437-page report, No Time to Quit, Engaging Youth at Risk, led by Professor Selwyn Ryan, which addresses exactly the same set of issues that are being proposed for the Watkins Committee.
Prime Minister.
Madam Speaker, if those issues were addressed, as my good friend would like us to believe, I would like him to assist by telling us how it was addressed, because the way it was addressed by Live Sport is quite different to what is being done now. This committee is to create an action plan for determining and taking actual responses to the situation. We are not Live Sport
Yes.
believers.
Supplemental, member for Opuchi.
Yes, to the Prime Minister. Does the Prime Minister believe that this is a proper use of both time and resources to establish a committee to do the exact work that was done before by another committee appointed by another cabinet?
Prime Minister.
Madam Speaker, the misunderstanding of the situation that is being demonstrated by my colleague from Orapuchis in no way hinders what is going to be done by this committee and this government.
Supplemental.
Is the Prime Minister in a position to say whether or not the government is embarking upon the work of a committee mere weeks before a general election so that an incoming government will have to pay for such work that was done already?
I rule your question out of order. Member for Couva North.
Madam Speaker, could the Prime Minister inform the House whether he intends to have government representatives meet with the communities of East Port of Spain, Beetham Gardens, and Morva for meaningful discussions?
Madam Speaker, all members of government meet with their constituents as their representatives on a continuous basis, and this week and last week and next week will be no different.
Member for Couva North.
Thank you, Madam Speaker. Given the impending general elections in this country and the fact that thousands of our nationals are still stranded in many other countries and are anxious to return home, could the Prime Minister inform the House when he intends to facilitate the speedy return of our citizens who would like to exercise their franchise in the forthcoming general elections?
Prime Minister.
Madam Speaker, the government of Trinidad and Tobago continues on an ongoing basis in a pandemic to keep its border closed as required and as advised by the health experts. But at the same time, we facilitate on an ongoing basis persons who are outside of the country, and we will continue so to do until whenever the borders are opened.
Supplemental, member for Couva North.
Thank you, Madam Speaker. Prime Minister, have you been advised by the Ministry of Health or the Minister of National Security as to when our borders should reopen?
Madam Speaker, the government is advised on an ongoing basis, and actions taken by the government will be determined by the advice at the time when the action is to be taken.
Supplemental, member for Caroni East.
Minister, do you have any idea of about how many nationals who normally reside here have made applications for returning back to Trinidad?
Prime Minister.
Well, Madam Speaker, there's no database of how many nationals who normally reside here, because there are persons who come here once in a while and regard themselves as residing here. And there are persons who are outside, and we try to facilitate in the context of what we are dealing with. And I just want to remind members that we are still in a global pandemic which is increasing around us, and we are responding to preserve the health of the people in Trinidad and Tobago. It is quite easy for members to begin to believe that there is no pandemic or that we have passed the worst. It is only that we have done well enough to evade the ravages of the pandemic.
Member for Caroni Central.
Madam Speaker, given the Prime Minister's mention in yesterday's press conference of the Mova Lavantil School Improvement Project, could the Prime Minister inform this House as to how this project has improved student outcomes in the 25 schools that were part of the project?
Prime Minister.
Madam Speaker, I crave your indulgence for some extra time to answer this question, and you may want to consider that, and my colleagues may want to consider it. Madam Speaker, with respect to literacy and teacher training and development, there was a 23% increase in the number of students scoring in the no-risk range of the oral reading fluency test, which was administered in the primary schools. along with a 43% in students moving up into higher category by Standard 3 compared to where they were in Standard 1. There was an 11% increase in the number of students reading at class level among the Form 1 students in the 2017 to 2018 academic year. Visual and performing arts was introduced as a strategy to teach literacy and numeracy. And Madam Speaker, with respect to numeracy, there was an overall increase in the average score of Standard 1 students on national test equivalent assessments, with 13 schools showing improvement at either the Standard 1 or the Standard 3 level, and 6 schools showing improvement at both the Standard 1 and Standard 3 level. There was a 34.2% decrease in the number of reported infractions with respect to violence and indiscipline. And during 2018, among the most noteworthy improvements were Laventil Boys Government Primary and Morvant AC, whose total number of infractions decreased from 21 and 25 respectively to 0 in 2019. There was a 56.7% reduction in the number of suspensions from 26 in 2016 to 11 in 2018. There was a 41% decrease in incidents of truancy from 78 in 2016 to 46 in 2018. There was a 55% reduction in the reported cases of bullying from 103 cases in 2016 to 46 in 2018.
Prime Minister, honorable members, the time for response to this question is spent. I did hear the Prime Minister's request, so I put it to the House, the wish of the House that the time be extended to complete this answer.
Yes.
Please proceed.
Thank you very much, and I thank my colleagues. There was a 53.8% reduction in the number of infractions recorded from 821 in 2016 to 379 in 2018. There was a 20.6% reduction in the number of suspensions from 320 in 2016 to 254 in 2018. Over the 2016 to 2018 period, there was a 12.7% decrease in the number of dropouts reported. There was a 41% decrease in the reported cases of bullying in that area at the secondary school level. With respect to primary and secondary schools, school discipline action plans were developed and submitted for all 25 schools in the program, and implementation has commenced. Basic procedures for ensuring orders in schools, inclusive of searches, patrols, entry protocols, and supervision rosters were developed and implemented in all 25 schools. Track and field saw the highest level of participation with an average yearly involvement of 48% of the schools, followed by football with 30% of schools. 625 students from 22 schools participated in the 5-day lunchtime musical production, which attracted audiences from around the area with parental support for the schools. With respect to parenting in education, Madam Speaker, a total of 718 workshop sessions covering 32 different topics were held in order to meet the objectives of parenting in education component. Individual parenting counseling sessions were held to assist parents to cope and minimize several psychosocial issues they were experiencing. A total of 514 parents benefited, 160 at the primary school level and 454 at the secondary school level. Several parenting initiatives were held inclusive of workshops, parent rally, parent volunteer week, parent focus support groups, parent outreach program, parent association group, parent space and parent exchange program. There were 3 fathers program sessions which were conducted to provide support to fathers, single fathers, and fathers of male students. 20 whole-day parenting in education sessions were conducted by the 4 disciplines of the Student Support Services Division of the Ministry of Education. A special education clinic was initiated for parents of children with speech and language delays. A parent in-reach support group was created in collaboration with NGO Foundation for the Enhancement and Enrichment of Life field. Parents and their children benefited from the community healthcare initiative that was provided by field. 315 homes were visited. They were conducted to foster among parents the importance of their children's education, improve the relationship between the home and school, engender care and protection of students, and to render any additional support and/or services the family may require. 95 parents received food hampers, clothing and shoes, cleaning supplies. And Madam Speaker, finally, a total of 488 students were screened. Of these, 325 were identified as at risk. Parent workshop addressed intervention strategies for this group. I thank my colleague for the opportunity.
Supplemental, member for Caroni Central.
Yes, thank you very much, Prime Minister. I'm heartened by the fact that there were metrics, and secondly, that the results seem quite favorable and progressive. Does that mean, Prime Minister, that this program will continue for some time? And is the coordination...
So one question.
Sorry,
yes?
I think I understand the question. Madam Speaker, the answer is yes. This program was a large pilot project. Given the results I've just read out, the pilot project has been very successful. And as was stated in the beginning, the intention is to continue it in the Greater Laventille area and to take it into other at-risk areas in the country.
Okay.
Supplemental, member for Caroni Central.
Yeah. Is the coordinating committee that was responsible for this still intact?
Most of it is. Most of it is, but it has been disrupted since February as a result of our response to the COVID-19. But we intend to reconstitute it and put it back on track because the track is obviously a good one.
Member for Shoguanasees.
Thank you, Madam Speaker. Honourable Prime Minister, could you tell us how much has been expended on this project to date?
The project so far, the expenditure has been $30 million, and most of that money has been spent in fiscal with respect to infrastructure and aesthetics. Refurbishment works which included toilet, plumbing repairs, pigeon proofing, ceiling repairs, electrical repairs, and structural repairs had the following expenditure. In 2016-2017, 7.2 million. 2017-2018, 8.8 million. And 2018-2019, 5.6 million. So the largest component of that 30 million expenditure was in the infrastructure side of it.
Supplemental, member for Caroni East. Supplemental, member for Caroni Central.
Yes. Prime Minister, will there be a strategy for protecting the beneficiaries of this program from negative influence in the communities that we know exist?
Madam Speaker, I'm not sure I understand the question. The entire program is meant to treat with the issues of negative influences on the community. What this is an intervention to do just that. That's what it is. The influences are all there, whether it is in the air, in the ether, in the soil, in the community. But these children are being made to respond positively to the influences around. And in fact, their progress will impact upon the negative influences that you talk about.
Member for Caroni Central, question number 6.
Yeah, question number 6, Prime Minister. Given that many businesses have closed permanently, having been unable to recover after months without revenue or support during the COVID crisis, does the Prime Minister intend to meet with business representatives to develop an appreciation from their point of view of what needs to be done to help them to survive and to recover?
Prime Minister.
Madam Speaker, the Prime Minister is a part of this government, and the government has been in contact with and have been treating with the issues of the persons identified in this area. There's no separate prime ministerial intervention. There's a government intervention. And may I, Madam Speaker, continue to respond in this way? With respect to the providing assistance to the business community, there's a $30 million grant facility administered by NEDCO, and that is available to small and micro businesses, Madam Speaker. And the businesses are eligible to access this facility, which include existing and previous NEDCO clients and owners of unregistered business. We've also, Madam Speaker, put in place stimulus for small and medium enterprises, $300 million help for small and medium businesses impacted by COVID. The loan is guaranteed by the government to grant a maximum of 5 years and a 2-year moratorium on the principal. The government guarantees 75% of the loan and no payment to be done for 2 years. The interest on the loan will be paid by the government and there are no handling fees. Madam Speaker, we also have done things like acceleration of VAT payments. We've done the credit union sector facility, putting $100 million in the credit union. All of these things and more, the government has done. So the Prime Minister is not to be separated from the government of Trinidad and Tobago.
Member for Caroni East.
Does the government have an appreciation of how many small businesses and medium businesses have been folded up or in the process of folding?
I will not allow that as a supplemental question based on the question asked and answered. Member for Caroni Central.
Prime Minister, I'm aware of some of the facilities that you mentioned that are being provided by government. But my difficult question to you is, are they working in the sense of, are these things being used by the people who are meant to benefit from them?
Prime Minister.
Madam Speaker, they will be used over time. Some persons have already begun to access some of them. Others are going to take some more time depending on what you are accessing. And also depending on the size of the business. We've catered for the small, the medium, and the large. And with respect to how quickly they'll be accessed, it all depends on the willingness of the beneficiaries to use them. And of course, we'll try not to be in a position where there are bureaucratic obstructions, which will slow down the process. But, Madam Speaker, they are all facilities available to the national business community.
Supplemental, Member for Caroni Central.
Is a particular difficulty for the 17,000 or so small and medium businesses with regard to the $300 million loan. In order to get through this crisis, Prime Minister.
Member, could you ask the question? Member, you have only
yes,
15 seconds.
it might require more than the 75 to 375,000, which is available in the system, and it may require less bureaucracy. Could that matter be looked into in the interest of the survival of these businesses?
Prime Minister.
Madam Speaker, wherever there are difficulties, and difficulties will exist in one form or another, what we have done here, Madam Speaker, as I outlined that part of it a while ago, what we have done is to look at the requirement to facilitate. And we have been as facilitatory as we could be. But if there are, in fact, situations which require further adjustments, they will be considered, but I can't say now what that will be, because we have looked at it with a mind to be facilitated. And that is what we have put here in terms of how much money, who's going to qualify, what period of time, how much the government will carry. These are all decisions taken after looking at the whole situation. But of course, Madam Speaker, as you would expect, there will continue to be demands, and we will look at those demands to see whether they're reasonable or whether it can be further facilitated.
Member for Naparima.
Could the Prime Minister, given the Prime Minister's admission that he is not encouraged by the track record of the Police Complaints Authority in bringing investigations to a conclusion, what does his government intend to do to ensure that the facts about the recent shootings of 3 citizens will be determined expeditiously?
Madam Speaker, I choose my word very carefully when I speak about the work of an independent commission, and therefore I will not respond to any reconstruction by my colleague from Naparima, and except to say that the Police Complaints Authority is an independent body, and I will treat it as such, question or no question.
Supplemental, Member for Naparima.
Mr. Prime Minister, why has your government in general, and the AG's office in particular, not addressed the issue of staffing and legislative empowerment raised by the Director of the PCA?
I rule that question out of order, having regard to the question asked and the answer given. Supplemental member for Naparima.
Does the Prime Minister have in mind an ideal time frame for the finalization of investigations into the shootings?
Madam Speaker, yes, expeditiously.
The supplemental?
Yes.
Supplemental member for Naparima.
Would the Prime Minister care to quantify that qualitative statement that does not make sense in this issue?
It might not make sense. It might not make sense to the member for Naparima because precious little makes sense to him.
Right. Member for Naparima, question number 8. Are you still asking that having regard to the supplemental questions asked by the colleague, the member for Oropuch?
Yeah, I'll still ask it. Could the
Proceed.
Prime Minister indicate why, in the light of the findings of numerous comprehensive state commission reports, including that by Professor Selwyn Rand on problems of inner city communities and youth in those areas, why is he setting up another committee to investigate the crisis?
Madam Speaker, that question has been answered.
Supplemental?
Yes.
Based on the answer.
Yes, I have a supplementary. Based on his answer previously, I have a supplementary.
Proceed.
Prime Minister, have you at all read the Ryan report? And could it not have been used to put in place programs to date?
Okay, I rule that out of order. If you're basing your supplemental on the response before, that has also been asked and answered. Supplemental member for Naparima.
Prime Minister, is this a strategy to buy time, give the impression that something is being done, and the hope that the issue would go away before the meeting office?
Thank you, Madam.
Questions on notice, public business, government business, motions. Yes, I have motions, huh?
Madam Speaker, may I ask for your direction, please, as happened in the Senate, whether motions 3 and 4 are to be taken together?
I believe for us it is motions 2 and 3. Attorney General, I believe the request, there's a procedure with respect to that, and I don't know if there was discussion between the leader and the whip. Whip, you have any?
Madam Speaker, I thank you for the opportunity to caucus with the Chief Whip via our Leader of Government Business. Madam Speaker, in seeking the debate of the motion number 2 for the Land Acquisition Requisition Order 2018, may I seek leave of this House to also debate motion number 3 with it simultaneously.
Is this the wish of the House?
Aye.
Please proceed, Attorney General.
Much obliged, Madam Speaker. Madam Speaker, I beg to move the following motion. Whereas it is provided by Section 5.1 of the Land Acquisition Act, Chapter 5801, hereinafter referred to as the Act, that the President may by order declare that land is required for a public purpose, and whereas it is provided by Section 5.2 of the Act that Parliament may by resolution approve an order made under Section 5.1, and whereas the Land Acquisition Requisition Order 2018 was made by the President under Section 5.1 of the Act as legal notice number 190, dated the 19th day of December 2018, and whereas it is expedient to approve the said order, be it resolved that the Land Acquisition Requisition Order 2018 be approved. For your guidance, Madam Speaker, do you wish me to read motion number 3 as well? Not just yet. Thank you, Madam Speaker. Madam Speaker, if I may proceed then. Madam Speaker, it gives me great pleasure to bring to conclusion a matter which has stood on our order paper for a couple of months, indeed beginning sometime last year. This matter, and as we get to motion number 3 as well, both matters of land acquisition arise out of parent law or legislation referred to as the Land Acquisition Act, Chapter 5801. This is an Act of Parliament, which, in fact, the member for Diego Martin West, the Honourable Prime Minister, acting in a previous incarnation, has a significant amount of experience with, as do honourable members opposite, and certainly members on the government bench. Madam Speaker, the fact is that the Land Acquisition Act permits the state, the Republic of Trinidad and Tobago, to compulsorily acquire land belonging to private individuals, belonging to citizens, if it is for public purpose. The provisions of Section 2 of the Act define public purpose as including the purpose of fulfilling any obligation of the state under any treaty or agreement made by the government with the government or any other country, territory or place, and any purpose pertaining to ancillary thereto. Part 2 of the Parent Act treats with land acquisition in general. Effectively, there is a rhythm to this process. One is obliged to invoke the process via Section 3. That is where it appears to the President, and President, of course, here is to be read as the Cabinet of the Republic of Trinidad and Tobago, that any land is likely to be acquired or required for purposes which, in the opinion of the President, are public purposes, that a notice to that effect shall be published. The process then takes you through to Section 4, where possession prior to formal vesting happens, and you can, in fact, within the time frame, which is less than 2 months after the date of publication under Section 3, the President may, if satisfied that circumstances of the case justify such action, issue an order authorizing the Commissioner, without waiting for the formal vesting of land under Section 5, to take possession and apply it for any public purpose. You then get to the provisions of Section 5 of the Parent Act. Section 5 has a subsection 1, 2, and 3 in particular relevant to this debate on these motions, where the President may by order declare that the land is required for public purpose, and Parliament may by resolution approve an order made under subsection 1. Very importantly, these orders stand as statutory instruments. Statutory instruments are treated with in our standing orders in a particular way. Both the standing orders of the House of Representatives and the standing orders of the Senate, and in our case, standing order 80 of the House of Representatives, requires that you must lay a statutory instrument, in other words, then an order, and it must be on the deck of the Parliament for 40 days. And that time frame, that 40-day time frame, you must consider the debates that we have. Now, the 40 days are calculated, Madam Speaker, under our rules of Parliament, not by 40 calendar days, but by 40 days within the prescription of how the Parliament sits and organizes itself. It is for that reason, Madam Speaker, that we've come now to treat with two particular matters, these two motions, one in respect of lands in Mayaro and the other in respect of lands at Princestown. Both of these two lands have in fact already been occupied by the state, in one case for 24 years and in another case for a period which is by far longer than that, since 1986 or thereabouts in Princestown. So let's deal with the Mayaro land first. The land which is the subject of treatment in motion is, in the first place, lands comprising 0.5793 hectares situated at light pole LV15 along the eastern side of the Manzanilla-Mayaro Road, Ottawa-Mayaro Village. And here we go to treat with that land having long ago, 4 parcels of land comprised there, having long ago been taken by the state and put into occupation for the alignment of bridge construction. The history of that tells us that proceedings for the acquisition of that land were initiated April 17, 1996, when the notice for acquisition under Section 3.1 was published by legal notice number 700 of March 8, 1996. The Section 4 notice was published as legal notice number 3, 12 December 1997, and pursuant to the provisions of the Land Acquisition Act, in fact, the Commissioner of Valuations gave a land value of approximately $125,000. That's by way of memorandum on the file dated January 21st, 2003, and a down payment of some $6,162 was paid to the person identified as a claimant entitled Miss Dolores Butte or Butte, depending upon how you pronounce the name. The Commissioner of State Lands wrote many years later, it was only in May 2016, that the Commissioner of State Lands, in tidying up acquisition, largely because the current Minister of Works and Transport and his predecessor were both engaged in making sure that all route alignment was done correctly, it was discovered at the Ministry of Works and Transport and in the work done by the Minister of Agriculture that this process for land acquisition was never completed. The advice of the Chief Parliamentary Counsel was sought, and the intention then was to just simply pick up the statutory instruments that were published. Advice was rendered under the Chief Parliamentary Counsel's hand, which pointed out to the existence of the rules of interpretation in Standing Order 80 of our standing orders here in this House, and the standing orders in the Senate, which effectively said, out of an abundance of caution, you ought not to proceed with that which was done so many years ago. You ought to refresh the process, and a new order ought to be published. As a consequence, the Cabinet took a decision on November 13, 2018, that we in fact rescind the Cabinet minute of June 3, 2004, which was a subsequent attempt to get this thing right, reissue the fresh processes, and finally cause the payment of the full sum amounting to $125,000 to the persons entitled to that land. It is with that process in mind, Madam Speaker, that we have engaged this Honourable House to tidy up the land acquisition process for the lands at Mayaro. I can confirm to this Honourable House that on the 21st of February 2019, in Legal Supplement Volume 58, number 21, that the gazetting happened. The gazetting of the Land Acquisition Requisition Order 2019 was dated the 18th of February 2019, and that land in Mayaro, as described in the order published on the 21st of February 2019, allows us to finally put the acquisition which happened so many years ago to rest and allow for the compensation determined by the Commissioner of Valuations so many years ago to flow into the hands of the persons entitled to that. I turn, Madam Speaker, to the second aspect in the second motion before us, and this is the lands at Princestown. Obviously, Madam Speaker, we are not with the benefit of a member for Princestown in this chamber, and nor have we had the advocacy coming from the last parliamentary representative for Princestown, who oddly enough features in this in a very interesting way. It was a motion under the name of Councillor Neela Khan, who was the past member for Princestown, who actually, on the 5th of July 2000, said to the Princestown Regional Corporation that the lands, the subject of this motion, that is lands at Realized Road, known as Pond Boys Recreation Ground, have been in fact used for over 20 years. So that is in 1980, these lands at Realized Road came into public possession. They were used as grounds for the benefit of the citizens. And it was Councillor Neela Khan in the year 2000, long before she became Member of Parliament for Princestown in the period 2010 to 2015, who actually wrote saying, look, we really need to put this thing to rest. Regrettably, that process was never completed. It was certainly not completed in the period 2010 to 2015, nor was it completed until it came to the attention of this government. And we insist, Madam Speaker, that these lands comprising that which has been published by way of legal notice under the hand of this government, that we actually, in legal notice number 190, issued the land acquisition order under the hand of the Secretary of Cabinet, as we're permitted to do, signing off for and on behalf of the President, in this case by Cabinet decision. And the lands that we're looking at are approximately 2.0234 hectares, more or less, being part of lands comprised of lands in Realized Road, Princestown, in the ward of Savannah Grande, in the county of Victoria. And what we're hoping here, Madam Speaker, is to finally bring to life the ability to vest these lands in the state once and for all, so that title is clear. Many years ago, Madam Speaker, the Commissioner of Valuations was involved in this process. The Commissioner of Valuations certified by way of memorandum the value that was to be applied in respect of the acquisition of this land. That value is $510,000, comprising some $425,000 for and in respect of the land, and contingencies of $8,500. That land acquisition was, the memorandum came since the 9th of September 2011. That, therefore, Madam Speaker, has been now 9 years outstanding, and it is important that we vest lands for public purpose into the state as is required under the provisions of Section 5 of the Land Acquisition Act, and that we complete these two long outstanding processes. Madam Speaker, there is no more rationale that needs to be put onto the record than those two particular positions, and therefore I beg to move in respect of both of these motions as per my submissions. Thank you.
Okay, so Attorney General, you'll be required to move the second one at a subsequent
Madam Speaker.
Okay, so honorable members, I will now propose the question for debate. Be it resolved that the Land Acquisition Requisition Order 2018 be approved. Honorable members, you are reminded that leave has been granted for motions number 2 and 3 to be debated together. Do I call on the Attorney General? Oh. Member for Naparima.
Thank you, Madam Speaker. I wish to indicate that I will be speaking on the land acquisition order with respect to the parcel of land on Realized Road, and my colleague, the member for Mayaro, will be dealing with the other parcel of land subsequently. So today, Madam Speaker, we meet to approve the acquisition of 2.0234 hectares of land on Realized Road in the constituency of Naparima, and not in Princestown, as perhaps was indicated previously. The land is used for recreational, sporting, and religious activities,
for the 2,500 residents of Realized Road and surrounding areas. And the acquisition is effected under the Land Acquisition Act, Chapter 5801, which prescribes a three-stage approach. Stage 1 involves Section 3 of the Act, the publication of the intended acquisition in the Trinidad Gazette and in twice in daily newspapers. Stage 2 involves Section 4 of the Act, which stipulates publication of the order authorizing the Commissioner of State Lands to take possession of the land. And that is done after the land is valuated, and we are told today that it was valued at $510,000 on the 9th of September 2011. Now, Stage 3, which is why we are here today, relates to Section 5 of the Act, which deals with the formal acquisition of this by the state and necessitates the approval of Parliament of the President's decision to acquire the land. Madam Speaker, this process of land acquisition involves the balancing of the rights of the individuals to enjoyment of property and the public interest of the wider community. Examples of the public interest to which private land can be used would include schools, would include hospitals, would include highways and recreational grounds. In this case, it relates to a recreational ground. And this is normal in all countries. In the United States, they call it the eminent domain. Some argue that the process is weighted too heavily in favor of the state. And sometimes the state itself may have to balance a number of interests, as the Prime Minister indicated yesterday with respect to the sun-turning ceremony for the Diego Martin overpass and administrative cent complex. It involves a balancing. And in some cases, the lands are acquired for, in the instance of Naparima, with respect to the Reform Hindu School and the Ben Lomond Early Childhood Center and the Reform Childhood Center. While the argument that these lands were acquired on an urgent basis is sometimes there are conflicts with respect to the urgency of the acquisition and the long time delay for finalizing the process, such as we have today. So we have situations where Children's Hospital at Couva, and that could be contrasted with the land that was acquired with respect to the...
I've given you some leeway, but please, we're not talking about acquisitions in general.
I agree.
There's a specific matter that you yourself told me that you're addressing.
And I'm getting to that
Thank you.
right now.
Get into it, please.
Right. The land is currently, the land that we are about to acquire is currently used for community, sports, cultural, and recreational activities. It is supported by the Realized Road community and approximately 2,500 residents of the area. It is used by and this is why I was speaking about the balance of usage and the benefits to the wider community. It was used by the nearby Lengua Islamia Primary School for sporting activities. It is used by many mosques in the area. It is run by a community group called the Pond Boys, comprising 300 members of the community. And it conducts coaching clinics for residents, young residents of the area. And they even do this in collaboration with the Trinidad and Tobago Cricket Board. The ground was lit in 2018 to facilitate night cricket. There is a 300-seat pavilion which was constructed by the Princestown Regional Corporation. And there's also a work center which, when completed, will serve as a community center. Madam Speaker, I say all this to say that we agree to support this acquisition. And if I'm given a little leeway, I will say whenever good legislation comes to the Parliament, we support it immediately. And I wouldn't detain this House by saying that we give support to good legislation, and I would have liked to say something about the bail bill and why we didn't support it, but I won't go there because
But you know,
I'll be
member,
stopped.
you're really taking advantage of the chair yourself when you said, if you're given some leeway, saying that you're out on
Now
a
I'm
limb.
talking to my colleagues.
No, you're speaking to me.
Yeah.
Please proceed.
While we support this acquisition, there are some issues which need to be ventilated in the public forum. And the first issue would be when we acquire lands such as this and which we support, it must have a clear, present, and medium-term use. Cannot remain like the Reform Hindu School for 10, 15 years. This acquisition is in our view, would be more effectively done if it was circumscribed by an fully operationalized procurement legislation. Cannot deny
Madam Speaker,
that
Standing
today
Order
we are
48-1,
acquiring
please.
property.
Madam Speaker, Standing Order 48-1, please.
Member, I agree with the objection. Please go on to another point.
Go on to
This is
another
not about
point.
procurement legislation.
All right. We cannot deny that today it took a significantly long time before acquisition and movement into the land and the final legalization of the process of acquisition. It took a long time. And because it took a long time, I am forced to ask, why on these occasions it takes such a long time? I'm told that there are shortages of valuators in the Town and Country Planning Office and in the Office of the Commissioner of State Lands. We have, as a country, to ask the question, and we will be failing the citizens of this country if we just deal frontally with the issue and not deal with the consequential contextualization of the problems which arise. So the result is, we are here today. I'm told that the land was occupied for the past 20 years by Pond Boys Recreational Group, and we are belatedly formalizing this acquisition. There are issues, Madam Speaker, with this land with respect to the title of the land. I see in the document they say owned by Ramphal, formerly owned by Ramphal. When I read the minutes of the meeting of the Princestown Regional Corporation, when they first advertised it, there was no one who came forward to claim the land. And they had to do it over again until they got people who said they might be related and they might be willing to sell the land to the government, the state. So the question of title again arises in the acquisition of this piece of land. And we have to ask ourselves, if we are to be a country that is moving into the 21st century, that we have to resolve all these issues. Madam Speaker, I move on. The piece of land was previously a pond. It was what we call in the country Bandan land. Those of us from South who know and from Maruga will know we're going into the Bandan. It was a pond, it was filled, it was utilized by the community. There was, in fact, there could be a query that the Pond Boys Community Group, they have been in possession of supposedly private land for over 16 years and therefore have a right to adverse possession. So these are issues relating to this that we have. Madam Speaker, this thing, the acquisition of land, should be a 4-year process. And I'm not saying our government is at 4, or their government. I'm saying that all of us together, working together, ought to put in process systems and procedures to facilitate a situation where we don't come 10, 15, 20 years after, everybody dead who has an interest in the thing, and call this governance and good leadership. Madam Speaker, there has been a consequential problem between the effective occupation of the land, which was 20 years ago, and the valuation of the land, which was done, I'm told, in 2011. And given the fact that we have an escalation in property values, we have to have a situation where we shorten the time frame between identification, occupancy, and legalization of the process, Madam Speaker. I know in the Act there's provision to pay 80% upfront, and I asked the Attorney General if this at all was done at the time, 80% in order to minimize that problem of inflation acting on the cost of the land. Madam Speaker, I just for 1 second, I spoke about the issue of title. If we do not deal with that, we're going to run into significant problems. The question about Tobago, there's a particular problem which I think we know, and I won't detain myself.
I want to advise one thing. The mere fact that every time I stand up, before I could say anything, you self-correct yourself. I'd ask you to, rather than do it as remedial, do it as precautionary.
Madam Speaker, since I'm obliged and forced to contain myself to the document, I think I've said enough. I would have liked to say more, but I'm leaving. Thank you.
Thank you, Madam Speaker, for acknowledging me to join in this very brief contribution that I have to deal specifically with motion number 3 with regards to the lands in Mayaro. Madam Speaker, my colleague, the member for Naparima, did take the opportunity to go through some of the periphery issues in terms of land acquisition, the relevant legislations that have been enacted. The Attorney General gave a step-by-step approach as to how we got from the acquisition of these properties to where we are today, where we are trying to bring legislation that is going to firm up the compensation to these families or the descendants of these families that who are owners of these properties. Madam Speaker, motion number 3 deals specifically with an order that the state, under the Land Acquisition Requisition Order 2019, Chapter 5.1, we are trying to get 4 parcels of land containing that 0.5793 hectares on the schedule to give the state the opportunity to pay these families. I have no doubt in my mind, Madam Speaker, that at all times, it is always necessary for the state to acquire land for public benefit, be it for the construction of a bridge in this particular instance in Mayaro, in the instance of Naparima, the recreational playground, and I'm sure over the years, lands would have been acquired to build roads, hospitals, and other facilities. So land acquisition, Madam Speaker, is a necessary feature of any government sustainable and infrastructural and development plans for the people today and future generations. So, Madam Speaker, I don't think anybody in this House can come today to object to any citizen being compensated for their property, especially citizens who have been deprived for one reason or the other for compensation for so long. What is unique about these 2 matters, Madam Speaker, is the fact that one is over 25 years, one is about 20 years, and that, to me as a legislator, as a member of this Parliament, who are representing people, it cannot be acceptable. Whatever is the procedures or the systems in place, clearly it is not working, Madam Speaker, and clearly we as a Parliament must find a method to make sure that these things that create these roadblocks in getting our citizens compensation when their properties are used for public interest, they should not have to wait 20 and 25 years. So, Madam Speaker, if I were to just go squarely into the issue of this property here in Mayaro, and just, if you allow me 2 minutes just to speak about what the Ottawa Bridge, that area. Madam Speaker, many years ago as a child growing up, Ottawa once had an iron bridge with wooden planks, and that was changed and replaced by a concrete bridge that has been raised to assist in the avoidance of flooding in the area. Madam Speaker, that bridge connected Mayaro with Sandy Grande and Port of Spain. Today, that bridge allows thousands of workers to traverse with ease between Mayaro and Port of Spain. Over the years, billions of dollars of worth of material and equipment for the energy sector would have been facilitated by way of this bridge, and clearly the value that the work that in the construction under that 1995 program under the UNC administration by former Prime Minister Basdeo Pandey, that made a huge impact into the fortunes of not only the country, but for the people of Mayaro as well. So, Madam Speaker, in doing a bit of research for this particular order, living in Mayaro as well, I reached out to a few of the families that are listed here. In this case, under Parcel A, Dolores Butte, Parcel B, Mr. Errol Mentor, Parcel C, Mr. Clunis Batiste, and Parcel 4, Mr. George Borvell, whom I've been speaking with his heir, Mr. Richard Borvell. Madam Speaker, in the instance of item B, I was informed by the relatives of Mr. Mentor that it's really Everall Mentor. I don't know if that will be an issue going forward, but Attorney General, perhaps if it will, perhaps it's worth noting that rather than Errol Mentor, it would have been Everall Mentor. So, Madam Speaker, based on what the Attorney General presented here today, I have a couple questions that I would just like to pose, some concerns that I would have coming out of conversations with the families. The Attorney General said that $125,000 is the value that has been proposed to be payable to the families of these 4 parcels. So, AG, just to be clear in your wind-up, if you could identify if it is $125,000 to be shared amongst all 4 families, or whether this $125,000 was for one specific family. The other query that I have, Attorney General, in your contribution, you identify that the family of Dolores Butte was already paid $62,000. And I have to ask, when one look at $125,000 for all 4 parcels, the family of Dolores Butte has 101.1 square meters, which is about 0.17% of the total acreage. But yet, that family would have received over 50%, almost 50% of the value of what you have mentioned of that $125,000. So I'm wondering if that is an error, or is that in fact the case at the end of the day? Perhaps you can just add some clarity to that. Attorney General, when looking at all 4 parcels, you are looking at about 5,800 square meters of land that has been acquired or in use by the state since on around about 2000, which gives you about 63,000 square feet. Now, Madam Speaker, if I were to do a bit of maths and look at $125,000 for that amount of land, it works out to under 50 cents per square foot. And I'm wondering, you know, based on the compulsory acquisition system that we've used as a state over the years, to me it really puts the owners of this property in a disadvantaged situation, because the value that is afforded to these owners of these properties, it's based on what would have been the perceived value back in 2000. And there is a concept of equivalence, as I understand in the law, and clearly there may be some issues in the fact that 25 years later, there may be no equivalence in compensation at the end of the day. So, Madam Speaker, that may be one of the issues that I think as a parliament, as a state, as we go forward, we must address this in some meaningful way. When you look at the issue concerning Mr. Bovell's estate in itself, in having a conversation with his son, Mr. Richard Bovell, which I sought permission to use some of the information, and he gave me permission to say it. Besides the property, Madam Speaker, he would have incurred loss of his coconut trees as well, because there were huge swaths of coconut trees which were all bearing and producing that would have been destroyed during the provision for the road and the construction of the bridge as well. So perhaps I would ask the Attorney General if in the valuation, perhaps the loss of the agricultural component on the estate, if that would have been factored into the $125,000 that is being, I think, shared amongst all 4 owners. So, Madam Speaker, you know, these are some of the issues that, you know, we must address as a parliament. We must be able to find some sort of equity for owners. I dare say, and I hope that projects that may have been conducted by this administration over the last 4 years, that properties, these owners would not have to wait 20 years.
Okay, so I'm not going to let you go on to other projects.
Sure.
Please.
No problem, Madam Speaker. Yes. So we're hoping that in the future, that whatever work we do as a parliament, that we can find a mechanism so future owners of property do not have to wait for 20 years and so on to get. So, Madam Speaker, in terms of the issue for those lands in Mayaro, we have absolutely no objection at this time in giving our support to this motion and allowing compensation to these families after a fair amount of time. Thank you very much, Madam Speaker.
Attorney General.
Thank you, Madam Speaker. Madam Speaker, it's quite refreshing to actually hear the opposition give its support for these 2 motions. It's refreshing, but I must say that it's also a little bit perplexing to hear the member for Naparima talk about doing more and, in fact, regaling us with all of the numbers for the people in the Princestown area. The member for Naparima spent some time telling us about 2,500 members that benefit from these grounds. 300 people, cricket, that in 2018, under this government, lights were installed for playing cricket at night. The honorable member said we cannot remain in this position, like he referenced the Reform Hindu school saying for 10 to 15 years. The honorable member says he can't deny that this took a long time. He's asked about title. The one thing that the honorable member for Naparima did not do was to simply apologize to the people of Trinidad and Tobago for the fact that the valuation having been received since years now, under the last government in particular, the honorable member failed to apologize to the citizens of Trinidad and Tobago for not concluding a process. And that is more egregious because there is a member for Princestown supposedly in this house who is notably absent. There is also the member for Siparia who leads that bench as senior counsel.
Madam Speaker, 48-1, please. 48-1 on a point of order. I don't know where the personal Princestown and Siparia.
And maybe if we give the AGLL chance, we'll see where he's going. Please proceed.
Thank you. Let me repeat what I'm saying and anchor it in relevance. There is a member for Princestown elected to this parliament. That member for Princestown has been absent from this parliament for a very long time. In the context of this motion, squarely within the section 5(1) vesting, which we're doing here today, the member for Naparima in his contribution failed to apologize for the fact that the member for Princestown has abandoned his constituency. And in section 5(1,
48(1).
I will rule on 48(1), AG.
I'll press on.
Please.
Much obliged. So that has been put to rest. And with respect to the position of the issue of the title to the land which is under acquisition here, I'd just like to say that the Honourable Member for Naparima perhaps missed the last 5 years in Parliament. It's true that in the last 5 years in Parliament, we've passed, in terms of primary legislation, amending legislation, and subsidiary legislation, over 537 aspects of change to the law. In fact, you may not know this, Madam Speaker, but this government has broken the record of every single government prior. And when we look to the amendments...
48(1).
I have to uphold the point of order made by the member for Urupuch West.
Yes.
So please get back.
And when we look to the amendments before us now in the motion proposed to the management of this land title, section 5(1) of the Land Acquisition Act, when one looks to these amendments, the issue of title in this particular case is solved by the work of this government, in the work that we have done in implementing the property, business, real estate solution and the computerization of records. That helps us to treat with the issue of title here. Because as the Honourable Member pointed out, the person who is entitled to this land is not known. In fact, to answer that particular position, it's important to reference the fact that there is a trustee located in the solicitor, located in the Chief State Council, acting at the Attorney General's office, and that public trustee is the person who will receive the proceeds of the balance of monies to be paid. It certainly cannot be the case that one can entertain any conversation from Naparima today on behalf of the absent member for Princestown that the persons who occupy certain areas in Princestown can apply for adverse possession. The issue of who is paid the monies pursuant to the vesting of this order is in default of a known owner. It will go into the state's possession. The issue of the public trustee will then go into effect. The public trustee will then advertise and diligent searches will happen. If no one can be found who is entitled to the monies for lands which have been in occupation for over 40 years, let me repeat that, 40 years, then that land, as it is converted to cash by the payment in the state, falls into the concept of bona vacanta, and it goes into the public purse. It will be paid into the consolidated fund after the processes of law are put to work. With respect to the member for Mayaro speaking to the public purpose of this particular aspect, it's true that one ought to really try to do these things in as current a cycle as possible so that land value is not deteriorated. So we're not talking about $125,000 or $500,000 in the other case, and that we are in fact looking at payment which is current into hand, because effectively you would have lost out on the benefit for the appreciation of your money had it been paid earlier. I mean, as a person who has done a lot of conveyancing in this country, I never cease to be amazed by the history of Trinidad and Tobago, where land could have been bought in multitudes of acres for $1,000 or for $24 at one point in time. Land value must be current. So, Madam Speaker, what I can say in answer to the member for Mayaro is that fortunately, you have a government that fixed the land titling issue. You have a government that has managed this acquisition process as tightly as possible. We have done what other governments have failed to do. We have done so on a current basis. With the new system going into effect by September of this year for property, business, real estate solution, we can rest assured that these lands, the subject of acquisition, just like every other land in Trinidad and Tobago, they have already been surveyed, and the geographical information has been retained, and that fits into the land titling structures. So fear not, Madam Speaker, these things are well underway in the radical reforms that this government has done. There's one last point. As the member for Naparima was wrapping up, he bid a farewell. He said goodbye to this parliament. And up until that point, I think that he was at risk of perhaps not being screened. But what I can say as I wrap up, Madam Speaker, is that the loss of Naparima to this parliament will be no loss to us at all as we move on to progressive work, Madam Speaker. And I beg to move.
Okay, so, AG, just before you wrap up, I want to rule on the standing, the objection.
Oh, I apologize, Madam Speaker.
Yes,
I didn't hear.
No, but in terms of, while we allow banter, we should sometimes respect the line when we cross to being less than parliamentary courtesy would allow to our friends on both sides. So I'll just ask you to withdraw and rephrase.
I'll happily. I bid Naparima farewell. Good luck, goodbye, thank you.
Honorable members, the question is, be it resolved that the Land Acquisition Requisition Order 2018 be approved. All in favor say aye. Aye. All against? The ayes have it. Attorney General.
Madam Speaker, I beg to move the following motion, standing in my name. Whereas it is provided by Section 5.1 of the Land Acquisition Act, Chapter 5801, hereinafter referred to as the Act, that the President may by order declare that land is required for public purpose, and whereas it is provided by Section 5.2 of the Act that Parliament may by resolution approve an order made under Section 5.1, and whereas the Land Acquisition Requisition Order 2019 was made by the President under Section 5.1 of the Act as legal notice number 34, dated the 18th day of February 2019, and whereas it is expedient to approve the said order, be it resolved that the Land Acquisition Requisition Order 2019 be approved. Madam Speaker, I beg to move.
Honorable members, the question is, be it resolved that the Land Acquisition Requisition Order 2019 be approved. All in favor say aye.
Aye.
Any against? The ayes have it. Attorney General.
Madam Speaker, I beg to move the following motion standing in my name. Be it resolved that the Senate amendments to the Urban and Regional Planning Profession Bill 2019 listed in the appendix be now considered.
Honorable members, the question is that the Senate amendments to the Urban and Regional Planning Profession Bill 2019 listed in the appendix be now considered. All in favor say aye. Aye. Any against? The ayes have it. Might I just ask, Whip, are you agreeable for us doing them en bloc? Or, yes? So, Clerk.
Clause 5, subclause 1, delete the word of. Clause 6, in paragraph A, delete the words for amendments to this act. B, in paragraph I, delete the word in and substitute the word to. Clause 8, in subclause 3B, insert after the word absent the words without the leave of the chairman. Clause 15, in subclause 1, delete the shackle and substitute the following. 1. No person shall practice urban and regional planning in Trinidad and Tobago unless B. In subclause 3A2, insert after the word council the word and. C. In subclause 3A, delete subparagraphs 3 and 4 and substitute the following. 3. At least A. 3 years post-qualification experience in work relating to urban and regional planning as recognized by the Council if the applicant has a Bachelor of Science degree, or B. 2 years post-qualification experience in work relating to urban and regional planning as recognized by the Council if the applicant has a Master of Science degree. Clause 18, subclause 1, delete the words or for. Clause 27, subclause 1, delete paragraph A and substitute the following paragraph. Refuse the issue or renewal of a license under sections 16, 17, 18, and 20. Clause 36, subclause 3. Insert after the word years the words and shall be eligible for reappointment. Clause 44. A. Renumber section 44 and 44.1. B. Insert after section 44.1 as renumbered the following subsection. 2. The members of the disciplinary committee shall hold office for a term not exceeding 3 years and shall be eligible for reappointment. Clause 50, subclause 1. Insert after the word breaches the words section 21 or. Clause 52. Insert after the word recommendations the words, comma, together with a record of the proceedings which may be in writing or in electronic form. Clause 53, subclause 3. In paragraph B, delete the word or and substitute the word and. Clause 61, A. Insert the word order. Insert after the word order the words subject to negative resolution of Parliament. And B. Insert after the words fifth the word sixth. New clause 5A. Insert the following clause after clause 57. Prosecution of offences, 57A. Notwithstanding any other written law, to the contrary, a prosecution for a summary offence under this Act may be commenced before the expiration of 5 years after the commission of the offence, or 1 year after the discovery thereof, whichever date last occurs. Fifth schedule. In Forms 1, 2, and 3, delete the word was and substitute the word is.
Attorney General.
Thank you, Madam Speaker. I thank you for the agreement, Madam Speaker, through you to the Honourable Member for Pointe-a-Pierre, the Chief Whip, to debate these matters together. And may I proceed immediately to jump to the recommendations. Madam Speaker, I'm very pleased that the Senate has tidied up the amendments that we've looked at in the Urban and Regional Planning Profession Bill 2019. If I could look at the amendments to Clause 5.1, and we go to that particular position. Clause 5 refers to the composition of the council. Clause 5.1 was proposed to be amended so that we could delete the word of, quite simply. This is just simply a grammatical tidying up, which has effect. In the chapeau at section 5.1, the council shall comprise the following 7 members, and therefore that is just taken for that purpose. If we look to the amendments to clause 6, we're causing 2 amendments. The first one is in clause 6A, and we have deleted the functions of the council as including, we've removed what is previously there, that the council should make recommendations for amendments to this act. That is outside of the purpose of the council. That is actually captured in a different area, and therefore the Senate considered that that was not appropriate for a function of council position. When we look to the second amendment, which is in subparagraph Roman 1, and we look to that particular purpose, we're simply tidying up the word in instead to the word to. If I go then to clause 8 of the bill, we're causing an amendment to clause 8, subsection 3. Clause 8 deals with a vacancy in office. It was thought to be the fact that we should really allow for absence pursuant to leave and not just a bare absence, because there may be legitimate reasons for members to be absent from meetings for 3 consecutive meetings. And therefore, it was important to put the fact that members could be absent with leave of the chairman to qualify what would be a harsh operation in those circumstances. I turn next to clause 15 of the bill, Madam Speaker. The amendments proposed to clause 15 of the bill, firstly in the chapeau, really that repeal and replace that we're looking at in the chapeau there is just simply to tidy up the fact that the reference to practicing in urban and regional planning is what the reference should be. Not that you are stopped from practicing as an urban and regional planner. That ties us back to the definition section, where there's a definition of urban and regional planning, and therefore it brings consistency to the utilization of language in the law. Madam Speaker, paragraph B of clause 15, we are adding in the fact of the combination of positions working. We're putting in the word and so that we have the conjunctive aspect. And when we deal with the conjunctive aspect, we're adding in at Roman 3 the qualifications in a different format. 3 years post-qualification experience in work relating to urban and regional planning, etc., and 2 years post-qualification as circulated. Madam Speaker, I turn next to clause 18.1, the removal of the reference to Roman 4 there. There was an inadvertent reference to it, and therefore it needed to be tidied up and removed. I turn to clause 27.1. Clause 27.1 is in reference to the provisions for appeals. And it was important that we don't confine an appeal to a subsection of the law as it was provided for 18.2 and 19.2. We've gone instead for the full sections, and you will see it as circulated, therefore, 17, 18, and 19, and not just the subsections of 18 and 19. Madam Speaker, I turn to clause 36.3. Clause 36.3, the Senate felt that it was important that members don't rotate out permanently after 3 years, that they should be provided with the opportunity to have an eligibility for reappointment. Clause 44 is amended, Madam Speaker. We're adding in, effectively, again, the concept of eligibility for reappointment. This is for the composition of disciplinary committee. The members of the disciplinary committee should have not just a simple 3-year term, but they should have a term which is consequent with them also having the ability to be re-elected or reappointed. Madam Speaker, I turn next to clause 51 as we come quickly to the other position. And if I look to 51, I'm adding on here the reference to a breach for disciplinary proceedings, the fact that you can trip section 21, which is the displaying of the certificate, harmonizes with the VAT Act and other provisions, etc. In clause 52, Madam Speaker, for disciplinary proceedings, the report of the disciplinary proceedings, we've asked for it to be tied into the fact that you must deliver recommendations together with the record of proceedings. It facilitates due process, and that we can do that in writing or in electronic form, consonant with amendments that we have done in the large package of laws in the criminal justice and civil arena. Madam Speaker, clause 53.3, we are simply putting the conjunctive operation of the sub-provisions, and therefore the word or falls out and pops in. In clause 61, we are adding the fact that the orders ought to be laid in the Parliament and put subject to negative resolution, and we're adding in the 6th schedule. Lastly, Madam Speaker, the new clause 57A, penultimately, the new clause 57A allows us for prosecution from offenses we're looking for a variation of the usual 6-month rule for summary offenses, and we're saying that they may instead now be commenced, prosecutions for summary offenses may be commenced before the expiration of 5 years after the commission of the offense, or 1 year after the discovery thereof, whichever is the latter. Lastly, for the 5th schedule in forms 1, 2, and 3, we deleted the word was, and of course put the present tense, which is. Madam Speaker, that constitutes the rationale for the several amendments brought from the Senate, and I beg to move.
Honorable members, the question is that this House agree with the Senate in the amendments to the clauses 5, 1, 6, 8, 15, 18, 1, 27, 1, 36, 3, 44, 51, 52, 53, 3, 61, the insertion of the new clause 57A, and the 5th schedule of the Urban and Regional Planning Profession Bill 2019. Member for Caroni Central.
Minute, Madam Speaker. We debated the substance of this bill here and put forward our views, and we have no objection to the amendments here that have come from the other place. They are cleaning up amendments and clarification amendments, and there's really nothing to object to. The one amendment that I really like is the 115, clause 15, no person shall practice urban and regional planning in Trinidad and Tobago unless, rather than having the other form, which was practice as a regional planner. I think that strengthens the notion of regional planning as a profession, and I think that it is quite positive. So that is the sum total of my contribution, Madam Speaker.
Attorney General.
Madam Speaker, it gives me great pleasure to simply say, I beg to move.
Honorable members, the question is that this House agree with the Senate in the amendments to the clauses 5, 1, 6, 8, 15, 18, 1, 27, 1, 36, 3, 44, 51, 52, 52, 53, 3, 61, the insertion of the new clause 57A, and the 5th schedule of the Urban and Regional Planning Profession Bill 2019. All in favor say aye. Aye. Any against? The ayes have it. The Leader of the House.
Thank you very kindly, Madam Speaker. Madam Speaker, I beg to move that this House do now adjourn sine die.
Honorable members, Member for Superior, I welcome you warmly, and therefore I'll just ask if we can proceed. Maybe Member for Superior, you can confirm that there are 3 matters on the adjournment. My advice from the Leader of the House is that these are not being pursued today. I don't see the whip here, so maybe you can just confirm that that is so.
That's it.
I'm sorry, Madam. Oh, please. I thought Madam Speaker was saying there are 3 matters on the adjournment and they will not be dealt with today.
I was just asking you to confirm. Okay, all right.
Madam, we have adjourned sine die. It means the Parliament is now dissolved. So nothing further will be done. Thank you.
Member for Naparima. Member for Superior. Again, I say I welcome you. I just hope that we will all abide by Standing Order 53. I really just asked you to confirm that your side is not proceeding with the 3 matters on the adjournment. Okay, I now call upon the Prime Minister.
Thank you, Madam Speaker. Madam Speaker, I am amazed at the ability of my colleague from Superior to cause disruption. I welcome her back to the chamber. But of course, Madam Speaker, she saw the opportunity to create disturbance. I don't know why. She has announced, but I will say, Madam Speaker, that today is a good day because it's the first time we've been in this parliament where my colleagues on the other side made a performance of supporting everything. And I'm very happy about that. I want to congratulate and thank my colleagues. Madam Speaker, we have come to the end of a term, as we're about to take this recess, where you have stood, normally I would say manfully, but I must say womanfully in that chair. And you have provided us with guidance, warnings, slight expulsions, but at the end of the day, Madam Speaker, it was a pleasure serving under your hand in this parliament. And I look forward, Madam Speaker, in associating with you in some way, maybe this way or another way, in the future, your tenure having been so distinguished. Madam Speaker, on this day, July 3rd, 2020, I am to advise all my colleagues in this House that I have advised Her Excellency the President to dissolve this Parliament at midnight tonight. That being so, Madam Speaker, as per our Constitution and the arrangements of our acts, nomination day, Madam Speaker, would be Friday. Nomination would be Friday, 17th of July, and polling day would be August 10th, 2020. I wish all my colleagues a safe, happy, enjoyable, productive campaign, and I look forward to seeing all of them somewhere in Trinidad before the next Parliament. I thank you, Madam Speaker.
Honorable members, the question is that this House do now adjourn sine die. All in favor say aye. Aye. Any against? I think the ayes have it. This House now stands adjourned sine die.